So here's that same statute on nexus. And here's the Sentencing Commission comments. So this is kind of authoritative commentary on the section. And we're talking here about section B, right? That's what we just read. And that the taker, the taker accomplished the dispossession by threatening or using force against the person. That's the language that appears to exclude any privilege for this nephew and uncle to recover their truck. Why would that be? Section B. Well, here's the official commentary. Let me zoom it in so it's easier to read. Sorry, folks. Lexis does this stupid thing where they put that box up. Oh, come on. Section B provides justification for the use of force to recapture property. That's what's happening here. Under very limited circumstances, the defendant must use or threaten to use force immediately after the dispossession. That's true here. And the defendant must reasonably believe the other person had no right to dispossess the defendant, so not a repossession case. Further, the dispossession must have been accomplished by the use of threats or force by the other person. This section is intended to encourage the resort to legal process, call the police, to recover property in all circumstances except those where immediate self-help is likely anyway. In other words, you're being threatened with force, or force is being used on you as part of the taking. And what have we been saying? The moment there's a threat to persons, it's not a defensive property scenario anymore. It's a defensive person scenario. So all this is really saying is you can't use force to regain possession under defensive property law in Tennessee, because you can't do it unless there's a threat to persons. And when it's a threat to persons, it's not a defensive property scenario anymore. Then we would have to look at actual Tennessee self-defense and defense of others law. In fact, let's go ahead and do that right now. Here we go. Self-defense, the Tennessee self-defense statute. So 3911, a bunch of definitions here. We don't need to worry about these too much. Deadly force, however, means the use of force intended or likely to cause death or serious bodily injury. That'll be relevant when we get to the second video, the members only video. And Tennessee has some very odd language in their self-defense statute. It reads, a person who's not engaged in conduct that would constitute a felony or Class A misdemeanor and is in a place where the person has a right to be, has no duty to retreat, so stand your ground, avoidance, off the table, before threatening or using force, and it doesn't say deadly force, so this is the non-deadly force provision, against another person when and to the degree the person reasonably believes the force is immediately necessary to protect against the other's use or attempted use of unlawful force. And then they have the same condition when it comes to deadly force. A person who's not engaged in conduct that would constitute a felony or Class A misdemeanor, as in a place where the person has a right to be, has no duty to retreat before threatening or using force intended or likely to cause death or serious bodily injury. That's deadly force now. If they have a reasonable belief that they're facing an imminent danger of death or serious bodily injury, and that belief is genuine, subjectively held, as well as objectively reasonably held. Here's the challenge for this nephew and uncle. Both of these provisions for the use of force in self-defense and defense of others, non-deadly self-defense and deadly force self-defense, have as a condition that you are not engaged in a Class A misdemeanor or, of course, a felony. Now, why do they have this condition? Well, they don't want, the liquor store robber who's engaged in armed robbery, a felony, they don't want him to have the privilege of self-defense. That wouldn't make any sense. The clerk pulls his own gun and goes to shoot the robber. We don't want the robber to be able to claim self-defense for shooting at the clerk. So we exclude from self-defense people who are engaged in conduct constituting a felony or a Class A misdemeanor. It doesn't seem too outrageous. Here's the problem for this particular case, however. If the nephew and uncle had no privilege to use force to recover the truck, because the truck wasn't taken by a threat or use of force by the thief, as we just discussed. If the nephew and uncle had no privilege to use force to recover the truck, but they threatened to use force against the thief to attempt to recover the truck, or to put it another way, the thief reasonably perceived that he was in imminent harm, imminent threat of bodily injury from the nephew and uncle. What do we call it when you unlawfully put someone else in imminent fear of bodily harm? That, ladies and gentlemen, is the crime of assault. And here's the Tennessee statute on assault. A person who commits assault when they, and I'll just pick the one that's probably most relevant to our scenario, they intentionally or knowingly cause another to reasonably fear imminent bodily injury. Now, if you're creating that fear in them and you have the justification of self-defense, then that legal justification relieves you of criminal liability for this conduct. And that's what we do anytime we threaten somebody with defensive force, right? We're intentionally creating in their mind a reasonable fear of imminent bodily injury. We're prepared to injure them in self-defense. The fact that it's self-defense provides the legal justification that makes that conduct not a crime. So if you were charged with assault and you believed you acted in self-defense, your lawyer would raise the legal defense of self-defense. If the elements of self-defense are met, even if you did meet the elements of assault, you're relieved of legal liability because the justification, that's how the justification defense works of self-defense. But if you did that same conduct and you don't meet the conditions of self-defense, you're acting unlawfully. It's just a crime. Now, here we're not talking about self-defense. We're presuming pre-machete display, right? So we're still in the defense of properties. Can you guys hear the train going by? Man, that guy loves his horn. So pre-machete, this is just the recovery of the property. But as we discussed, the nephew and uncle may have had no legal privilege to recover the property because the property wasn't taken by threat or use of force by the thief. They're supposed to call the police under plain reading of the Tennessee Defense of Property statute. So if they didn't have any justification to use force and they created a reasonable fear of imminent bodily injury on the part of the thief, well, they had no justification for doing that. And if they didn't have a justification for doing that, they committed the crime of assault. And if they committed the crime of assault under this paragraph A2, the crime of assault under paragraph A2 is a Class A misdemeanor. Remember where we last saw Class A misdemeanor? We saw Class A misdemeanor in Tennessee's self-defense statute. Here. Because you lose the privilege of self-defense if you're engaged in conduct that would constitute a Class A misdemeanor.